Well, Dr. Zerkel, welcome to the 2016 Indiana Resource Center Focus on Inclusion Conference. We are thrilled to have you here with us.
Thank you. The real Elisa. I appreciate that.
And while you're here, one of the topics that you're going to be presenting on is around the current issues in special education and what we need to be aware of that's coming. And could you speak to that for a few minutes? When we think about the whole of special education, what's the critical issue or two that we need to be aware of?
Now remember that my particular dimension or field is law. So we're talking about critical issues in special ed law, which certainly are part of the larger field of special ed, but just like our informal conversation, law provides sort of minimum legal requirements for things like FBAs and BIPs, but should not be confused with what I call the lore, which is hearsay, best practice, perceptions of the law. But in general, my advice is, as both for administrators, teachers, parents, stay on a trusting level of best practice, trying to do the best one can with limited resources, and then the law becomes largely irrelevant. But if we do go down to that level and look at what is here and what is coming, a big issue is new IDEA reauthorization. Now that the NCLB has been resolved in terms of the Every Student Succeeds Act, Congress and our country will be turning to national policy for disabilities in how do we need to change the IDEA, including harmonization with ESSA. And to me, the biggest issue for the various stakeholders to consider and hopefully fine-tune as a legal requirement is what is the substantive standard for an IEP. Up until now, for the past 40 years, we've been following what ended up being codified or originally decided in the Rowley case, a very low floor-based standard, which is an IEP must be, at the minimum, reasonably calculated for educational benefit. That is a very low level compared to what most parents and most professionals seek. And in my view, we need to consider raising that substantive standard, because we now have 40 years of funding, experience, research, and just like the medical field moves up in terms of things like expectations for cancer therapy, pardon the analogy, but at least a critical issue like cancer, a critical issue like educational effectiveness for a child with a disability, and for all children, we need to raise the ante in terms of outcomes. If we can do so, we're going to get closer to best practice and focus on what seems to be most important to parents, children, and our society. The trade-off, then, is to become less intrigued with some of the things that presently occupy people like me, which is all of the procedural issues. Who needs to be at the IEP team? Which goals? Which objectives? What does stay put mean? And all of the other technicalities. And in my view, just like the federal government is now evaluating states who are now evaluating districts for accountability on primarily outcomes, we ought to get in sync with that in terms of outcomes for children in terms of FAPE. To me, that's a central but very difficult issue as to whether to change it. If so, how high does one move it, and what does one sort of trade off in the same process? That's the large, big issue. Now, the other, if I had a second choice, it would be, again, looking at federal policy legally. How does this whole notion of 504 and the ADA fit with the IDEA to make a prudent, logical policy that practitioners and others can follow? Right now, if I'm a parent attorney or a district attorney and I'm trying to optimize the chances for my client, I look at these multiple avenues and sometimes sue under ADA, sometimes 504, sometimes IDEA, sometimes federal constitution, state constitution, and you end up getting this bewildering array of different standards. Oh, and by the way, I was chatting with one of the participants here, and she came up to me and asked, how do I find out more about a lot of the concepts you've been talking about in these cases? Because we recently lost a case. And I said, lost a case? What kind of case? And it turns out she was talking about a parent who had gone to the Indiana State Ed Department for what we call complaint resolution process. Well, that's a different avenue entirely in terms of, one, the modality. It's investigation rather than adjudication. And the legal standards, something like implementation. You don't implement the kid's IEP, you only implement it 90%. Most complaint investigators say you owe the parent 10%. Courts use an entirely different standard. So once again, it would make it less litigious, and we'd be spending less money on people like me and transaction costs if we had one sort of sensible, unified, harmonious approach as to what the legal standards are. I buy into the notion of having state variety above the federal policy, but right now we have, in effect, 3 or 4 different federal policies as far as what the basic minimum is.
So do you think we may get some clarification on these issues or guidance?
One can only hope, but there, unlike what I do most of the time, which is studying these court cases as objectively as I can, now we're talking about politics. And politics are tricky because we have, as you can see in the current presidential candidates in both parties, quite a range of views in terms of what makes sense for policy and the interaction between the executive branch through the president and the legislative branch in terms of Congress, and then the administrative agencies, which right now end up doing something that is generally useful to avoid impasse, which is compromise. But when you have compromise, often it causes contradictory directions and this sort of crazy quilt pattern that I've just been talking about trying to solve. And whether we have the national commitment to get together politically on major issues, whether it's immigration, whether it's global warming, or in this case, education, including education for children with disabilities, one can sometimes get cynical about. But to me, that would resolve a lot of the current litigiousness, confusion, and finger pointing.
Well, there's a lot for us to take a look at and listen for as we move forward in the next couple of years with decisions being made.
It's true. I'm just going to add one. If you had asked me what are some sort of current hot button issues, just listing them quickly, that this crazy quilt causes, it includes things like concussions, and whether that's protected under IDA or 504, service animals, which is an ADA issue and a state law issue, bullying, which cuts across all of these statutes as well as the Constitution, gender identity issues, which has an odd sort of interaction with special ed or students with disabilities, giftedness and how that plays in, especially for the twice exceptional student, is a quick sampling of much smaller, but right now sort of critical issues to try to figure out legally. But once again, coming back to my message, if people in good faith of various perspectives can work together with limited resources to optimize what would be best for the individual child and the collective, it will make irrelevant a lot of the litigiousness about these issues.
Well, thanks for those insights. We appreciate that. And thank you again for being here.
Thank you, Elisa.